Good afternoon, everyone. Ready to get started? Welcome to our program today entitled Big Brother in the Office, Helping Nonprofits Manage Employee Privacy in the Modern Workplace. My name is Jeff Tenenbaum, Chair of the Nonprofit Organizations Practice here at the Venable Law Firm. Welcome to those of you here in our D.C. office joining us for lunch here. Today, a nice crowd on a somewhat dreary March afternoon in D.C., and welcome to the a fairly large crowd that we have on the telephone here today across the country participating by webinar. As you know, or as many of you, if not most of you know, this is part of a monthly series that we've been doing for actually a year now. It'll be a year next month. A monthly seminars and webinars on nonprofit legal issues, sometimes adjunct, not just pure legal issues, but we try to cover a wide array of hot-button nonprofit legal topics every month with our complimentary seminar and webinar series. For those of you who are in D.C., we always encourage you to come join us for a free lunch from 12 to 12:30 Eastern Time. And then for those of you who can't come, either in D.C. or around the country, our programs always run from 12:30 to 2 o'clock Eastern Time. And I'll let you know what some of our upcoming scheduled programs are very shortly. Let me briefly discuss today's topic, and because we do record these seminars and keep them posted indefinitely on our website, I'm going to give a little bit of a detailed description for those who will be listening in the future. Our program today is a topic that's actually been touched upon in a number of the prior seminars we've done on employment-related topics for nonprofits, but it's an area that is so rich in interest, so many interesting wrinkles and complexities, so many questions that arise in this area that we felt it really deserved a seminar all of its own. Technology enables nonprofits to monitor employees' activities more than ever with the increased use of social media, personal use of employer equipment, and business use of personal smartphones, laptops, and iPads. The lines between public and private information have never been more blurred, not only for current employees but also for applicants subject to background and credit checks. So what can you do and what can't you do as an employer to monitor your employees' online behavior, for instance, both in and out of the office? What can you do to maximize your employer's rights to do this kind of monitoring? How can your employees' online activities put your nonprofit at risk, and what can you do about it? This program is going to provide a legal overview of the evolving contours of both employer and employee rights and responsibilities in the workplace privacy area. In addition to reviewing important new developments in the law, we're going to provide you with practical advice and recommendations for policies and practices to best protect your nonprofit from privacy pitfalls. We have two very distinguished speakers with us today, two of my colleagues with whom I work very regularly and frequently and have for many years in the employment area. They counsel hundreds and hundreds of our nonprofit clients every year on these and related employment law issues. To my immediate right is Dave Warner, a partner in our Labor and Employment group, and to his right is Grace Lee, an associate in the group. Both are absolutely terrific lawyers in every respect, do a terrific job both counseling our nonprofit clients to keep them out of trouble in this area and then coming to their defense and even representing them in court and in other proceedings where necessary to try to keep them out of trouble. I think you're in for a real treat with both of them here today. And they not only both understand the law in this area, they both understand nonprofits extremely well, but they also have a real knack for kind of relaying things in a very practical, easy-to-use manner, which I think you'll very much appreciate. A few logistical details, issues here, questions and answers. For those of you in the room, we encourage you to ask questions throughout the program. Obviously, if our speakers are getting into a bit of a flow in a given topic, maybe try to hold your question until the end of that flow, but definitely feel free to ask questions throughout. If we do get a bunch of a series of questions, we might have to cut it off and save questions for a bit later, but please do raise your hands throughout, and I'll call on you, and our speakers will repeat the questions for those of you listening in on the telephone. For those of you who are on the webinar part of our program today, you'll need to utilize the chat feature on the webinar to send questions, and I'll be monitoring that from the front of the room, and I'll pose those questions to our speakers throughout the program. And then, of course, we'll also try to leave some time at the end for additional questions. For those of you in the room, you have a booklet of handout materials that includes the PowerPoint slides. Those of you who are on the webinar will, of course, be able to see the slides. And then tomorrow, everyone, both here and on the phone, will get an email from us that has a link to the recording of today's program along with a PowerPoint presentation for your own use and to share with your colleagues who might be interested. Also, I want to give you 2 web links that may be of use to you. They're also on the last page of the PowerPoint presentation, or I'll just highlight those for you. First, all of the recordings and related PowerPoint presentations for our monthly seminars are available at venable.com/nonprofit/recordings. And all of our 600+ articles, PowerPoints, and other resources on nonprofit legal issues are always available at venable.com/nonprofit/publications. You can search all of those by topic area. Let me give a plug for our several scheduled upcoming programs. On April 12th, we're going to be doing a program entitled Lobbying and Political Activities, Rules of the Road. There's going to be a program targeted both at 501c3 and 501c4, 5 and 6 organizations. We're going to cover a wide array of kind of new developments, important kind of timely election year related issues, and also a lot of staple issues that you're going to need to, that you always want to know about. It'll be a good refresher as well as an update on new developments in this area and things to really pay attention to. There's some terrific speakers for that program. On April 20th, we're going to do a second program next month, a bit of a unique, different format. It's going to be a program from 4 to 5 p.m. Eastern. There will not be a webinar component, unfortunately. I don't believe that may be the case. We haven't decided that yet. But we're going to have a program from 4 to 5 p.m. and then a reception at 5 o'clock here in our offices for those of you who can join us, a cocktail reception. The program is entitled Good Counsel, Meeting the Legal Needs of Nonprofits. It's going to feature Leslie Rosenthal, who's the General Counsel of the Lincoln Center for the Performing Arts in New York, who just authored a terrific new book with that name that's really a fantastic guide to all of the legal issues confronting nonprofit organizations. And she and I will be doing that program, and I think you'll find it very entertaining and informative. On May 17th, kind of a back-to-basics program, nonprofit contracts, best practices, negotiation strategies, practical tips, and common pitfalls. This may not be the most exciting topic that we cover over the course of the year, but perhaps it's the most meaningful and important in that for all of us in our nonprofit group here at Venable, contracts are probably what drive us more than anything else on a day-to-day basis, and probably many of you as well. There's many, many things that we've learned in our group over the years in this area, so we have a lot of, I think, helpful tips to pass along to you guys. And then finally, on June 13th, it's actually scheduled out to June so far, a program entitled 10 Best Practices for Protecting Your Nonprofit's Intellectual Property. It's going to be a really interesting program covering both copyright and trademark issues with a couple of our colleagues here who do extensive work with nonprofits in this area. A couple of folks I want to recognize here in the room. In the back of the room is George Constantine. George chairs our regulatory practice group here at Venable and has been really a co-leader of our nonprofit group for years and years and years along with me. George is an integral part of our nonprofit team, and I know many of you know George from working with him and otherwise. And hanging out in the back of the room here, making sure we have no technical difficulties, is Jamie Fitzsimmons. Jamie's our marketing specialist who's been absolutely phenomenal helping to organize these programs. So with that, it's enough preliminary remarks. I'm going to turn it over to Dave Warner to get us started. Dave?
Thank you, Jeff. And again, let me just reiterate for the folks in the room as we move forward, if you do have questions, we encourage those, so just please raise a hand and we'll take as many as we can. Wanted to start talking a little bit, why are we concerned about employee privacy? What's bringing us all here together today? And the primary driver really is technology and the continuing evolution of technology. Is anyone in the room here familiar with Moore's Law and the theory of Moore's Law? I have a couple of nodding heads. Gordon Moore was the founder of Intel Corporation, and back in 1965 he made some statements that have since been developed by professors at Caltech into what's referred to as Moore's Law. But basically Moore's Law is that every 2 years technology doubles in its ability to process information. And his projection has proven remarkably consistent since 1965 when he was talking about the number of transistors you could put on a chip. And now it seems to be holding true even in the world of silicon and semiconductors. The practical effects of this are pretty obvious. I always like to think about the movie Wall Street and Gordon Gekko, and there's this scene when he's talking on a high-tech cell phone. And it's sort of this 3-pound brick that he's holding next to his head, and you can almost see the radiation coming off of it. You move forward 20 years, and now we have this. You get internet, cell phone, email, text, video, television. If I had the time, I was going to participate in the webinar to do the full meta thing and email Grace questions while she was talking. They have become incredibly complex, and other features including pictures and video and audio recording. Let me give you a very real-world example. About 3 weeks ago, I was in a deposition. I was deposing a plaintiff in a discrimination case. And part of my usual intro is to go through, do they have any documents that they haven't produced? I said, do you have any recordings that you think are relevant to this case? She says, long pause, and she says, well, I might. I said, okay, what might you have? I said, I might have recorded the termination meeting. She just simply had a cell phone in her pocket and opened up a call when she was going into the meeting with her supervisor in HR. She had a 16-minute audio recording that was very, very clear. And thankfully, the meeting was handled very well. But it was something that would not have happened 10, 15 years ago. And it's something that's going to be continually more prevalent as audio recording devices, cell phones become more and more small, easier to conceal. What are some of the other workforce realities that are driving the concern? For years and years, we've been told it's an aging workforce. It's an aging workforce as the baby boomers continue to age out and are now beginning to retire. And what we're also seeing is now the echo boomers are coming in, and the workforce is actually getting younger in some regard, and that trend will continue as the baby boomers retire. We're dealing with a generation that is immersed in technology at a very young age, and that's not something that they can simply turn off, or that we as employers can expect them to turn off. So it's a part of their lives, and it's coming into the workforce. The challenge for employers is keeping up with the pace of change. And what doubles that challenge is the fact that the law develops very, very slowly. There are not sea changes in employment law, particularly when you're dealing with the evolution of legal theories in the court system. And so the law is always trailing technology, and it's always trailing social mores. Now, the good news for the overwhelming majority of the folks in the room today and online is that we're not public employers. We're not the government. So the rules of the road when it comes to monitoring and what private employers can and can't do are much broader because we don't have to concern ourselves with issues of search and seizure and constitutional rights. But that said, there are rules that do apply, legal theories that can apply in terms of invasion of privacy and the like, that it's important for employers to be proactive and have policies and practices in place that will permit them to gather information when they choose and use that information in employment decisions. So, as Jeff mentioned at the outset, it's becoming increasingly easy for employers to monitor employee activity. And really, if companies want to, they can collect just a torrent of information. And there are programs that allow IT professionals to monitor things as mundane as the number of keystrokes that employees make within an hour to determine if people are on task, websites visited. There's software that can screen the images on screen to determine the pixels and the color of pixels that help identify if someone's surfing pornography in the workplace or viewing pornography on an email picture. They are imperfect tools, however. One recent example was a client who was concerned that they had an employee who was day trading at their desk because their software program that monitored internet activity had this person logging in and out of a program multiple times throughout the day. And they were about to take adverse action. They were going to discipline the employee and possibly terminate them on the basis of this. We said, well, let us take a look at the website and see what may be going on here, because it was not a problem employee. It was someone who was performing actually rather well. And what happened is the employer was very interested in how his stock portfolio was doing and would open his website and just have it running in the background. But it was constantly refreshing with additional information. So every time it was refreshing, their program was monitoring it as a click. So what looked like an employee who was spending virtually their entire workday clicking and checking stocks was no more than someone who had just had something up and running in the background so they could pull it up. So again, it's just an example of how this torrent of information can be useful, but can also be very, very misleading. One of the emerging problems with all the technologies is the ability to monitor working time. With texting and phones, people could be on the clock constantly. Now, this is not a problem for exempt employees, such as lawyers, executives. We're expected to be on the clock constantly. But it can be a real challenge for hourly employees, because if an hourly employee is provided in a BlackBerry, for example, and if there's an expectation that if they receive an email that they respond to it, even outside of working hours, the time that they're responding is very likely to be considered working time. And even if it's de minimis, if in the aggregate that becomes half an hour, 2 hours, 3 hours or more, in any given work week, that's going to create a very significant potential issue for the employer. Another issue is the use of hardware and the blending of work and personal life. How many people in the room have two devices, one for professional use and one for personal use? Grace, I had no idea. What's interesting, it's a relative handful of a room of probably 50 or 60 folks. I think we had maybe 4 or 5 hands. We'll talk about that issue later, but it creates a significant problem for employers because you have someone that has a device that they think of as personal to them, but if it's touching your servers and if they're performing work, people my friends on the plaintiff's bar are not going to say, well, that's just a personal device, so I don't want to see it. So that can create real compliance and very nettlesome employee relations issues as well as legal issues. I also mentioned the explosion of social media and the real blurring of people's professional lives and their personal lives. This has been compounded with the explosion of texts and tweets. It's sort of like email squared and the issues that we had with email squared because they tend to be very, very permanent. Once you put something out onto the internet, if someone copies it, it's very easy to forward. People tend to think of those types of communications as informal, so they're more willing to say something quickly without thinking through, could this be misinterpreted? You don't get tone of voice. And again, the law is really only beginning to catch up with this. And what's interesting is that I think the social mores are evolving even faster. I was reading an article in the New York Times, I think it was last week, that was saying there's this notion that spring break in Florida is actually getting tamer. And the theory was they interviewed several college students who were down there, and they said, well, I don't want to end up on Facebook or YouTube. And it's really a very quick evolution of people becoming ever more aware of the permanency and the proliferation of easy video, that anything you do can and will be posted on Facebook whether you like it or not. So it will be interesting to see how that continues to evolve and how it affects us as employers. Some survey information. Here, the first bullet point here is my favorite, that 79% of employees had used email to send or receive personal messages at work. What I took from that is that approximately 21% of employees are liars. Grace will talk later about some policy implications and policy recommendations, and one is the notion of a blanket ban on personal use. It doesn't work. Usually the chief violators are going to be your executives, but then the 83% of employers that have rules and policies in place, that's terrific. If you know any of the 17%, please tell them about Grace and I. We'd be happy to work with them to put some things in place. The email and overuse being a cause for discipline, relatively common. Touched on this a little bit earlier. Where we really see the email and the problems with email tends to be in the harassment context and discrimination context. Given its permanence and the fact that some people, for whatever reason, still think it's like a private communication, so it's fine if I'm sending off-color jokes to my coworkers or my friends using my employer's email. All of that's discoverable. All of it comes in, and it can prove to be very, very difficult for employers. Now, the monitoring mentioned in the fourth bullet, again, becoming ever more common. Just out of curiosity, again, how many of your organizations have active email or either email or internet use monitoring programs at your workforce? Yeah, several. With that background, I'm going to hand things over to Grace to talk a little bit about the legal framework and how that is evolving.
Thanks, David. Well, as David said, the law is quite lagging behind in the technological advances that we all and all of our employees have access to. But I did want to talk about some legal frameworks that are in place and that have been used to interpret cases and to develop new laws. With each new situation that arises, we sort of look at, well, what's the precedent? How would that correlate to an in-person situation? Is an email that has harassing information in it akin to a conversation in the lunchroom where harassing comments were made, and therefore do we have a legitimate interest as an employer to look at that information? So the first law that I want to talk about is the Electronic Communications Privacy Act, and this on a federal level is sort of the overarching foundation. And what it says is that generally it prohibits the unauthorized or intentional interception of wire, oral, or electronic communication during the transmission phase. So while the email is going from your computer to your colleague's computer or your client or your members. And it also prohibits the unauthorized accessing of electronically stored wire or electronic communications. So obviously it covers all forms of digital communications, including private email or internet use or social media use. And this law gives many the mistaken belief that they have privacy in their emails, or employers mistakenly believe that they are not allowed to review, a certain level of private emails that employees or, colleagues or members are using on their internet. There are, however, two very important exemptions to the Electronic Communications Privacy Act. And most employers, especially most nonprofits, are going to fall under one of these two exemptions. Number one, if the employer is a provider of the email, internet, network service, then that does not apply. ECPA does not apply, and you are not prohibited from monitoring or intercepting or accessing information, digital communications. Number two, and this is the one that we're going to probably spend more time on today, is that the employer is exempt from ECPA if there's implied or expressed consent of the employee. So for example, if you in fact have a policy in your handbook that employees sign and they acknowledge that they don't have an expectation of privacy in the communications or information stored on the work computer, personal emails that are transmitted through their work computer, or even through a Yahoo account or a Hotmail account, if it's still through your server, you can allow, the employer is allowed to monitor that communication or intercept it, and it's not a violation of ECPA because basically the employee has consented to that search. The other is implied consent. So maybe we're not so great about collecting a signature from every single employee that walks through the door. However, we do have a clear policy. Maybe it's emailed out to everyone periodically. It's in our handbook. One employer had a flash screen pop up anytime someone opens their Outlook or their Explorer from their work computer. Just a reminder, we're allowed to monitor this. This is not private. There's no expectation of privacy. And so by an employee continuing to use your email, your internet, your computer with that understanding is considered implied consent. And basically these two exceptions give a lot of leeway for private employers to, first of all, decide what the level of privacy is going to be in their workplace. And obviously you have to balance a lot of different things like employee morale and also what you have to do as an employer to protect your legitimate business interests, your trademarks, your confidential information. So you're weighing all of this, but you as an employer have a lot of discretion to sort of frame how you're going to develop these policies. And we're going to talk about that in a little bit. The important thing also is that if you don't have a policy, time and time again, cases have been interpreting this law to say, yeah, the employee should not have had an expectation of privacy. There was a clear policy in place. and this monitoring was not a violation of their privacy. On the flip side, when that kind of policy is not in place, it leads to a lot of litigation, a lot of questions about what was the subjective expectation of someone's privacy, what was the practice of monitoring, what did employees know about that, and as you can see, it's very gray, it's very vague, it's very fact-intensive. So the clearer you can make your policy and enforce your policy, the better shape you're going to be in terms of not only preventing litigation, but also getting yourself out of trouble if you are presented with a claim. Another sort of legal framework issue I want to touch on is the Fourth Amendment and a little bit the First Amendment. So, for government employees and governmental entities, there are certain constitutional rights that employees enjoy against search and seizure. And again, this is not going to apply to most of you, but it's something to be aware of because there are cases that are interpreting that even in government settings, certain privacy rights don't really exist as much as we thought they did. And employers can look at personal computer interactions if there is a legitimate interest, if they're doing an investigation. So again, it's very case by case, but wanted to let you know that that's also out there. Sure.
So with regard to the private email account, Hotmail account, for example, forget about Gmail, Hotmail or Yahoo. So if there's a notice then by the employer, then that the employee has no reasonable expectation of privacy, and they can read the mail. Does that include a keystroke recorder to record passwords and screenshots? Can they only read the mail that the employee sent or viewed at the office, or can they glom onto the password and log onto all of the emails on the weekend?
So the question is, for a Hotmail account or Yahoo, and apparently Gmail reads everyone's email anyway, so we're not worried about them, what is the extent of the monitoring that can take place? Is that correct? So can an employer track password and keystrokes? Can they take screenshots of the Gmail account while it's on the computer? What about when they're accessing it from home? And potentially, this raises a good issue. If you can sort of figure out that person's password by looking at the keystrokes, you could access their whole Gmail account or Yahoo account and look at their entire private file. And again, the law does not specifically say this is okay, this isn't okay, password's okay, this is not okay, but you have to sort of frame your policy and weigh whether or not, weigh the privacy interest against the legitimate business interest. So you can't necessarily have a policy that for any reason or no reason at all, we're just going to ask you for your Yahoo account password, or we're going to just figure it out and read all of your Yahoo email from the beginning of time. That being said, there is sort of a middle ground of, we are concerned about excessive personal email at work. We're concerned about people using their personal email to disclose confidential information, trademark information. We're concerned about people using personal email to harass or discriminate against other employees, and therefore we maintain the right to monitor the use, to take screenshots, and you have to be pretty specific about that stuff because you're right, it's pretty the framework of what employers can and can't do based on technology is pretty wide. And I would be very specific in the policy about, we're going to look at your screenshots. We're going to look at your keystrokes. We're going to, if there's an investigation or if there's litigation and we find out that there is communications happening on the Yahoo account, that is subject to investigation, that's subject to discovery. The more specific you can be and the more you can tie it back to the legitimate business reasons, the better you're better off you're going to be.
I think as a general rule, a couple of general statements. There are no bright lines in this area. And from a policy perspective, what you don't want to end up, or from a strategy perspective, you don't want to end up being a test case. Test cases are great fun for the lawyers. They end up with appellate issues, and we like that sort of stuff from an intellectual capacity. After your first $150,000 in legal fees, you're no longer going to be interested in being a test case. I think generally, if what you're talking about is activity that's occurring on your network and on your machines, So long as you have clear policies in place that talk about what we do monitor, what we can monitor, what we may monitor, you're going to be on a stronger legal footing. But as you start going down, the hypothetical that you were spinning out is, okay, well, can I capture the password and start using it for reasons other than monitoring what the employee is doing at work? That begins to get into an area that would give me a great deal of pause as a management lawyer, and I would probably only be comfortable with doing that if there was a very, very strong business reason that I was doing that. So for example, if you had an employee that you thought was stealing trade secret information or is engaged in other illicit activity, then the balance might be, okay, I'd be willing to accept the risk of a counterclaim of invasion of privacy tort because I've got that strong business interest. But I would weigh those very, very carefully. But again, I think one basic principle is if you're talking about your equipment, your machines, your network, probably a wider range of options than when you start moving away from that.
So Dave, just to clarify, and maybe you can elaborate a little bit more, because this is a very common question that we get. What you're suggesting is that the policy to allow for certain types of monitoring at a minimum be tied to the employee's utilization of an employer-provided network or equipment in some way. It doesn't necessarily have to be in the office. It doesn't even have to be an employer-provided home computer or laptop or PDA. It could even be to someone accessing their Yahoo account through the employer's network that they've logged in from home on their own personal laptop. Or it could be that they're using an employer-provided laptop, but you're saying at a minimum there should be some connection to some employer-provided equipment or network in order to provide that link to do any kind of monitoring at all. And then beyond that, kind of the level of monitoring and tracking and perhaps accessing passwords should be more kind of on a case-by-case basis depending on what sort of business interest is at stake and how severe the risk is.
Yeah, I think that's right, Jeff, because again, I think we would want the policy to make clear that when you are using our equipment and our machines, we really have plenary authority to look at whatever we would like. I don't think, though, that we would necessarily want to limit our policy to activities that are on our machines and on our network. Because again, to the extent the employee is out there engaging in work on your behalf, whether it's using their Hotmail or your acme.com website, they're your agent, and you're going to be on the hook for what they're doing, and you do have a business interest in being able to obtain that information from them. So it is a balance. I do think, again, we want to be clear that when you're working on our network, we can look at everything, but if you're engaged and if you're using a personal device for work purposes, we want to have access to that.
I think that it comes up even more frequently in the new, sort of use of social media. So a lot of people are on Facebook, they're on Twitter, they're on LinkedIn, and that it's from their home computer, their own network. It has nothing to do with our equipment or our network or our devices or anything. And yet, as they are representatives of you as your organization, they might say something that would reflect badly upon you as an employer or as an organization. And yet, let's say their Facebook account is through their, work email, or it says on their LinkedIn where they work, and they're using that to broadcast really, defamatory, disparaging remarks, using it, we've seen a lot of lawsuits about this, to disclose confidential information about the workplace. I think that employers absolutely have a right to take action in those situations and to put employees on notice that when they represent themselves on these social media websites as a representative of where they work, that it's not a free-for-all. We can still look at that. We can still use that as a basis for taking employee actions. We had one situation where one employee had a blog. It was very discriminatory. It was a personal blog on a personal computer, a personal network, and yet another employee found that blog because you know what? It's out there in the world and anybody can access it. And the employer got involved because the other employee found it to be very, very offensive and said that this was discrimination and it's creating a hostile work environment. And even though it wasn't on their network, the employer absolutely had to get involved and take a look at that blog and see, whether or not it was appropriate or not in the workplace.
Yeah, we had a client that 7 different employees at the client. This is a client that kind of counsels consumers in a particular area, and 7 different employees were using their Facebook accounts to kind of post personal confidential information about some of these counseling sessions that were occurring with consumers, and very sensitive information, kind of poking fun at them, things like that. And all of it, not all of it, some of it was done on their own personal time, on their own personal computers, not through the employer's network. But certainly the employer had every right to, once it learned about it, to look into it and to access the Facebook accounts. And then, of course, ultimately they terminated all the employees.
And we'll talk about this in a bit more detail later, but an employer's ability to respond or to use the types of discussions that may occur on Facebook is really not absolute, because there are overlays of labor laws, whistleblower laws, anti-retaliation provisions, and the like that will apply. And it's interesting because in some way, as I said at the outset, the technology is changing, but the legal framework is not. The fact is that we just have more access to information now. I mean, when the labor laws were put into place that are in play, it was 6 guys sitting around a bar griping about their manager, and management was none the wiser for it. Now they're doing it on Facebook, and management's wiser for it. But the same laws apply, and we'll get into sort of where some of the rules of the road are when we do have information about some employee statements and what we can and can't do when we're aware of those.
Grace, I have a question from someone on the webinar, which is related, so I'll pose it now. We're talking about an ability for employer to perhaps surreptitiously track or personal use of Facebook and other social media, perhaps even surreptitiously track password keystrokes in order to access that without the employee's knowledge. But one of our participants says, what about the recent stories in the news that involve employers asking potential employees for their Facebook login and password so that they can check those Facebook pages as part of the background check they do on prospective employees. Do you want to comment on that?
Sure. I think there's a couple of considerations there. I mean, number one, it's just generally not a good idea from an employment law standpoint to have that kind of access. There's a lot of other tools that you can use during an interview, background check, and reference process to get key pertinent information about an applicant. But once you've got access to that Facebook account, suddenly you could find out what kind of disabilities they have, what kind of chat groups they're on about their religious beliefs, how many kids they have, the fact that they're going through a divorce and the ex isn't picking up the tab for school. I mean, you don't necessarily want to know all of that because it could lead to claims of, well, gee, I never told you about any of that during my interview or my application process. It has nothing to do with whether I can do the job, and yet now you're not hiring me. How do I know it's not because of what you found out about my disability or my religion or how many kids I have and stuff like that? So from an employment perspective, it's generally not a good idea. And we recommend using sort of the other tools available to you. But yes, do employers Google their employee or potential applicants before they come on? They do. I mean, we just know that for a fact that people go on and Google someone and check out their Facebook and see what sort of information they can glean from their public profile. But to come out and ask for that information and let the employee know that you're absolutely looking at that private information, it goes a little bit beyond, a big step beyond that, and it's not recommended. From whether they can do it or not, I don't think there's, they can, but it's not a good idea. It's not recommended.
Yeah, it falls into the is it lawful? Yes. Is it advisable? Don't be a test case.
Well, we could, be fun for us. But turning back a little bit just to get back on track to the legal landscape, again, sort of from the federal perspective, we've got ECPA, we've got constitutional rights, and then from a state perspective, there are some states that are sort of starting to manage this a little bit better, look at it more. There's, anti-bullying laws out there, what people can do on Facebook, but there's not, again, it's still lagging, and state is even further behind, but there is, for example, in Connecticut, you have to notify someone when and where you're monitoring them. So before, you can't just surreptitiously, check everyone's computer screen every 5 minutes. You have to notify them when it's going to happen. Other states have tried to pass laws like that. So far, that hasn't happened. Under common law, obviously, you're subject to any kind of, for any of your activities that could potentially violate someone's privacy, you're going to be looking at a tortious invasion of privacy kind of lawsuit, defamation, and there's other common laws, that sort of can create a basis for someone to bring a lawsuit against you or to bring a claim. The key issue with all of this, which we've already been talking about, obviously is whether there was a legitimate expectation of privacy. So setting that expectation, clearly communicating it to your employees in the handbook, in a training, reminders over email, whatever you need to do to sort of be able to defend against, I didn't know you could monitor that. I had no idea that just because I hooked up my personal iPad to my work computer that suddenly you had anything to do with what you're taking my iPad to look at it now. You really want to be upfront about what those expectations are. We're going to talk later about what you should put in your policies. But again, really think about the balance between the privacy interest and legitimate business interest. And those, again, are lots and lots of activity on email and Facebook and internet, which leads to harassment claims, discrimination claims, pornography, inappropriate jokes. All of that stuff is a huge problem in the workplace. It's recognized by courts as a legitimate business interest for employers to use as a basis to monitor workplace email and internet activity. Again, anything about maintaining productivity, that's a legitimate business interest. And of course, protecting your information, your member list, your trademarks, your strategic initiatives. That is all, again, stuff that you want to protect and will give you the basis for looking at someone's email or invading their privacy. One case which I wanted to highlight for you because it is at the Supreme Court level, it talks about personal text messages on an employer's device. And this case is important for a number of reasons. First of all, just to give you a little bit of background on the case, it's a public employer, so police officers had a government-issued pager, and the police officers were sending texts, multiple texts. Actually, they were sex, so it's now called the sexting case, but sexually explicit messages, if you don't know that lingo yet. And the employer decided that they wanted to search and look at those texts because they were concerned about whether or not those police officers were using their device for work-related purposes. And in this case, interestingly, they even had a policy that they will not audit those texts as long as the employees paid for any over-limit fees. But because of a concern that, overusage and whatnot, they did a search of these text messages and found them to be very inappropriate, sexually explicit, and took action against these two employees as a result. This case went all the way up to the Supreme Court, much litigation, a test case, which you do not want. And the Supreme Court found that the employer had a legitimate interest in looking at those texts, which trumped the employee's privacy interests. So even though this was in the government setting, all the more reason for us in the private setting to realize that the Supreme Court and other federal courts are recognizing legitimate business reasons for looking at even personal texts on, in this case it was a government-issued device, but even when their policy wasn't clear, in this situation, this investigation was legitimate. Imagine if a policy was clear, it probably wouldn't have even gone to the Supreme Court. It would have been disposed of at the lower level. So again, there are some court cases here and there, and it's courts and cases are catching up, but I just wanted to give you sort of the framework, the factors that courts mostly use when they're looking at whether or not there is a reasonable expectation of privacy, because really that is the key determination here. Number one, does the employer maintain a policy banning personal or other objectionable use? Number two, does the employer monitor the use of the employee's computer or email? Number three, do third parties have the right or access to the computer or emails? Because if they do, that obviously implies that there is very little expectation of privacy in those communications to begin with. And number four, did the employer notify the employee? Or was the employee aware of the use and monitoring policies? Those are really the key factors that courts are looking at, and it's case by case, but a policy, for example, that says you have no right to privacy in the company-issued laptop that we give you, goes a long way. A lot of people take those company-issued laptops and they do some work on it, and then they do some Facebook, and they download some pictures, and they're on YouTube, and they've got all their music playlists on there. Guess what? That's not private, and when you leave the organization, we're taking, a lot of places have internal policies, they give a chance for people to get that information off of their pictures, whatnot. But that hard drive is our equipment, and we're taking it back. So really important to have clear policies on that.
And it's also important to note that under U.S. copyright laws, everything created by employees within the scope of their employment by their employer is automatically owned by the employer. And it doesn't matter what sort of device it's maintained on. So not only is the equipment the property of the employer, but the intellectual property, the copyright to the intellectual property that's created on whatever piece of equipment is the property of the employer. Those rights exist regardless of what your policy is, but you want to make sure that you have policies that help to facilitate the ability of you to kind of collect that copyrighted information back when you're done. Now, it doesn't mean that if some employers might not care if an employee keeps a copy of something that they did at work, as long as the employer has a version of the original on the employer's hard drive at computer network at the office. Every employer might deal with these issues differently in terms of the importance of wanting or allowing employees to keep copies of works that they did. But at a minimum, you certainly want to make sure that the employer has copies of all final original work product of everything that the employee did and created during the scope of their employment. Did you have a question here?
Yeah, I had a question on the prior slide. The second bullet, does the employer monitor the use of email? How does that kind of mean? Are you recommending that we do in order, as employers, in order to preserve our right, or is it that we need to tell the employees that we have the right to monitor? Or what if you don't have the resources to monitor?
That's a good question. So the question is, on the previous slide, does the employer monitor the use of employees' computer or email? So that is a factor that courts will look at. And the question is, does that mean that we actually have to monitor the emails and the traffic in order to be able to enforce our policy and stand behind it? Or is it enough to simply say, because of limited resources or whatever, that we reserve the right to monitor email? And absolutely, both types of policies have been litigated. And it has been found to be enough to say that you have the right, you reserve the right to monitor an email with or without notice. So I know a lot of you may not have the resources to monitor all the time, and some of you may not want to because you want to build trust in your employees and things like that. There's other reasons not to do it, and so you're not giving up your right to do it just because you don't actually monitor frequently everyone's internet traffic.
Grace, does that apply, for example, if in a retailer that has video monitoring in the stockroom, maybe on the cashier, because the cashiers frequently will ring you up for $5 for a $5,000 fur coat or something like that? Does that also apply? That way you have to tell people that they're going to be monitored.
Right.
Use that because all the time, you see in the paper, a gas station has their monitor on, and something occurs across the street, and that ends up with the arrest of the suspect and whatever. I mean, where does this all end? I just heard a.
But we got to just cut the question. If I can ask you to keep your questions brief, because for those on the phone, there's a lot of dead air during that time. So try to keep them as concise as possible. You guys want to try to address the question?
You want to go first, or shall I? The question was around video monitoring and sort of what the permissible scope of that is, and that's really an entire seminar unto itself. But the basics are that if you are monitoring in an area that is open, so if you're in a public area and you have a camera that's on a cashier, the law is very clear that the cashier, as they're standing there, has no reasonable expectation of privacy, because they are in an area that can be observed. And there's also, if, for example, you don't do video monitoring, but you believe that someone's stealing from a stockroom, that is in an enclosed area that's locked and employees don't have access to? Can you have a video camera installed to identify for purposes of the investigation? The law is very clear that yes, you can do that. But outside of those areas, if you're, once you move from public places to areas that appear to be more private, such as employee break rooms, bathrooms, there's a lot of case law, particularly coming out of the union context, about break rooms and what can and can't be recorded in there. But generally speaking, the same legal analysis is going to apply, starting with what's the expectation of privacy, and then moving from there. And did you have a comment, Karen? Yeah, just for the folks that are online, the comment was that when they were monitoring, be it email or sexting or otherwise, it is unfortunately not, I won't say it's not unusual, but it does occur that things are happening where you have reporting obligations, the most obvious one being child pornography. And unfortunately, in 15 years of practice, I've had more than a handful of cases where employers did have that issue arise, and there are mandatory reporting requirements. Sometimes there are things you don't want to know, but once you do, there are obligations that kick in, and it's a good reminder that there are state law implications to all of this, so you really do need to be cognizant, and the states handle them very differently, and that again is really a seminar unto itself to understand. It's just important that it's not only the federal overlay, there are state and local laws that are implicated as well.
Absolutely. So let's talk a little bit about telephone monitoring. It doesn't come up as much as an issue or a concern that we receive, but just so you know, employers may, again, with proper policies in place, monitor business-related calls. Note, in case anyone's on the phone from California, that the California law requires that when parties are on a call in California and they're being monitored, they have to be informed that their conversation is being recorded. And then you may hear a lot about, this conversations being monitored for quality purposes, and that's where that comes from. Again, also under federal case law, there's been an interpretation that when an employer realizes that the call is personal and there's no other legitimate business reason, like you're not doing an investigation about, sort of criminal conduct or, other legitimate reasons, that he or she must stop monitoring the call. So it's not actually as easy to monitor telephone calls as it is to monitor Internet activity. So it doesn't happen quite as much. But sometimes when there is an investigation going on or there's litigation, that kind of stuff does come into play more often, including voicemails and those kinds of recordings.
Yeah, and the telephone monitoring, that grows out of the wiretap statutes. And what's interesting is there are very different state rules. Some states are one-way consent states, others are two-way consents. The most two obvious examples are Virginia and Maryland. Virginia is a one-way consent. If one party to the conversation consents to its being taped, they can do that. Maryland is two-way consent, as Linda Tripp found out back during the Whitewater. And same rules apply to telephone monitoring. So if you're an employer in Maryland and want to monitor, it's great that you're telling the call that's incoming that your call may be monitored for quality control purposes. But generally we suggest that they have a policy that the employees who are on the phone sign and acknowledge that, yes, I understand that my calls can be monitored or recorded, because Maryland is a two-way consent statute. Oh, yes, question in the back.
Yeah, so you've gone over many of the U.S. requirements of authorities in privacy law. So it turns out in the late 90s, the EU passed an omnibus privacy policy law, actually. And in order for U.S. companies to do business with Europeans, the Department of Commerce got a safe harbor privacy policy approved by the EU. And many U.S. companies, multinationals, have signed on to that policy. And that is much more restrictive and protecting of the privacy than in a general sense to the U.S. law does. So my question is, for U.S. multinationals who have signed up to the EU's privacy safe harbor, Department of Commerce safe harbor agreement, how does that affect any of the things that you talked about here?
The question is, how does the EU Safe Harbor agreement or accord affect what we're talking about here? To the groups that have signed up for it, and generally you're talking about multinational corporations. The short answer is I, as an individual, don't know. The longer answer is that we have an extremely robust and sophisticated privacy practice at Venable with the likes of Milo Cividanis and Stu Ingus, whose practice is really focused on privacy-type issues and helping multinational, and part of that is helping multinational corporations, have policies in place that are compliant both with the U.S. law, EU, and then once you're outside of the EU, when you're in Central South America or in Asia, all the rules are different all over the place. So not only is that a seminar for another day, that's a multi-day seminar in Geneva for that one. So my apologies for not having a crisp answer, but that's
just follow up with me separately, and we'll get you an answer then.
Okay. Back to sort of the legal landscape, and I'm going to turn it back over to David. Just to summarize, when it comes to computer monitoring, with the right policies in place, and again, that's the key issue here, employers can see what is on the screen. They can see what's stored on computer terminals, stored on hard drives. Employers can monitor internet usage, such as web surfing and electronic mail. Company email is owned by the company and can be monitored and reviewed. Even private emails sent from computer, from the company computer to or from Yahoo, Hotmail, or other websites can be monitored or reviewed. There was a recent situation where there was an exception to this, which has been kind of rare because employers are given a lot of latitude. But there was an employee who had a personal account, was accessing it from work, her Yahoo account, and exchanging emails with her attorney about her concerns about what was happening at work. And, claims of discrimination, harassment, what do I do? And that was deemed to be attorney-client privilege. So when the employer went ahead and looked at those emails and promptly fired her, that was not okay. So I'm going to turn it back to David to talk more about the sticky issues about personal and private devices.
And this is an issue that comes up a lot because individuals tend to be very tied to their personal devices, and probably all of us in the room either are or have friends who fall into the early adopter category, that whenever Apple comes out with its next generation of iPhone, they are front and center at the Apple Store. And they always want to be using the newest technology, and they don't want to use your 6-year-old BlackBerry that you're providing to them for purposes of their email. And from a practical standpoint, many, if not most, employers are say, that's fine. You can use the device that you want. And that's great, but you do, again, stepping back a second, the legal framework is going to be the same in terms of our ability to access information that's on that device. So what is that expectation of privacy that the employee has? And it's important from an employer's standpoint to be very clear that they have no expectation of privacy in their personal device. Here at Venable, we can use personal devices. We have to provide them to our IT departments. They can load on software that allows us to get email through the firm's network. And it's made very, very clear that when we no longer have that device, or if we want to upgrade, that device comes back to the firm. It gets completely wiped, and then it gets handed back to us completely empty. No contacts, no personal information, no personal email, etc. And that's the same as when you leave the firm. You have to turn your device in before you can leave, so it can be wiped, and it's returned to you virtually a brick, other than the battery and the operating system. Yes, question.
David, you can sync your contacts before then. I don't get that.
You can certainly. Most people. The question is, the observation is, you can sync your contacts before then, and that's absolutely true. But that's always been the case. That when you have people that use laptops, can they make a copy of it before they turn it in? Sure. Can I find out pretty easily that you've made a copy of it? Yes, I can. Can our network show that you've synced your contacts or stored them to an external drive? Yes. Do I, as an individual and non-tech savvy lawyer, have any idea the amount of metadata that's stored on this thing that can track everything I've done? I don't. And even if I did, my ability to be able to wipe it is probably relatively limited. Thankfully, my wife's relatively sophisticated, so that's her job if and when I leave the firm. No. But your point is a good one, because there are practical limitations. But some of the important implications of what we're talking about, again, is to limit the employee's expectation of privacy, so that when issues arise, like the person is a witness in a discrimination case, that they're the accused discriminator. And I say, we've got discovery that's come in. You use your personal device for purposes of work. I know you do, because I get your emails from your Mac account. You've got to get me the device because I need to respond to discovery. I want, as an employer, the ability to say, and here's the policy that you signed that said I can do this. Now, even in the absence of something like that, if the employee stands on principle and says, okay, well, I'm not going to give it to you because I think it's full of private information, the practical implication of that is my friends on the plaintiff's bar is going to say, well, that's fine. Mr. Warner, here's your third-party subpoena. I'd like your phone. And then we'll still have that dispute. It'll be between the plaintiff and the individual. I, as an employer, am still going to be implicated because it's all my case. It's my name that's in the Metro section about the sexual harassment case going on, and now it's going to be creating interesting law on electronic discovery. But you're again absolutely right that there are practical limitations to our ability to contain information, but there are still very good reasons that we want to have those policies in place, because they do have practical effects in other contexts, namely in litigation.
Just as a follow-up, so the recent issue that's going on that who owns, they call media custody. So who owns the Twitter account, the followers, or the LinkedIn, who owns the followers? Have you been following this?
The question is whether or not I've been following the cases in who owns Twitter followers and LinkedIn data. And again, the short answer here is that I have not. From an employment lawyer's perspective, I'm less interested in the question of who owns it as I am who's going to be implicated by what's in there. Because that's often what affects the employers the most, and that's why the policies are again written in such a way that we have the degree of control that we can have over what is said on Twitter, what's said on LinkedIn, what's said on Facebook, which conveniently takes us to our next slide.
Actually, Dave, one quick question from the online folks. How does the expectation of privacy on personal devices used for work purposes, I think it means, is that expectation of privacy limited to or lack of expectation of privacy, I should say, limited to the work elements of that device, or does it extend to personal emails and texts and other exchanges on that personal device?
I think as an individual, I would have an argument if my phone was subpoenaed that the only thing that's relevant and should be discoverable is information that is work-related. The practical implication of that, though, is that someone's likely going to have to look at all of that data and make a determination whether it's a lawyer on the other side, whether it's a lawyer from my employer, or whether it's the third-party vendor that is tasked with culling the data so that only my non-private, or rather only my work-related emails are shared. A recent story was out with a client who was talking. They had recently gone through a very sensitive litigation, and she said one of the outputs was virtually all of my employees are now two-device people, because they did get the subpoena where everyone did have to turn over their personal devices because everyone was using them for work purposes. And she sort of chuckled and reached into her own purse and pulled out two phones, just like work phone, personal. So back to the question, as a theoretical matter, yes, the only thing that should be in play is your work-related email. But from a perspective of, are they going to let me scrub all my personal stuff out before I turn it over to the lawyers, the answer to that question is almost certainly no. Dealing with social media, as I touched on this again briefly before, that really it's the technology that's changed and the ability to capture information and not so much the law. And when we're looking at what are the types of actions that employees can take, or employers can take rather, when they're aware of certain conduct, be it online or otherwise, from employees, one of the principal laws that's implicated is the National Labor Relations Act. Now, generally speaking, I make that statement and most of the people in the room say, well, I don't have a union, so why do I care? Well, the National Labor Relations Act does not solely apply to unionized workforces. It applies to every workforce. And specifically what it protects is employees engaging in what's referred to as concerted protected activity. And what that is employees engaging in conduct that's for their own mutual aid and protection. And it's triggered when even an individual employee is making statements or engaged in conduct that relates to the workplace and working conditions, and they're doing it either with other employees or with the authority of other employees. And this is an area that is extremely, extremely gray. So let me give you a few recent examples of conduct that the National Labor Relations Board considered to be protected concerted activity. One dealt with an auto dealership, and it was an employee who was on Facebook with coworkers, and he was complaining that they had served hot dogs at a recent sales event. And he said, we're a high-end dealership, we should have been serving better food. Management finds out and cans him, files an unfair labor practice with the National Labor Relations Board. They determined that that was protected concerted activity because he was complaining together with other employees, and because he was a salesman, he was in effect complaining that your shoddy food cost me money. I would have made more sales, made more money had you all served better food. Reinstated with full back pay because that was considered protected concerted activity. Similarly, 5 workers getting together and griping about criticisms in their performance evaluations. They were doing it online and Facebook, saying, our supervisor's a complete dope. I can't believe we got these bad evaluations. We're the best thing at that place. Again, terminated, unfair labor practice. It's a non-union environment. All 5 reinstated with back pay because of engaging in protected concerted activity. Again, an area where there are simply no bright lines. But if an employee is saying something that relates to the workplace, relates to a working condition, be it pay, be it hours, be it supervisors, you have to tread very, very lightly because it does not cost much. Actually, it costs nothing to file a charge with the NLRA, and they run with it from there. It's not something where the employee has to lawyer up and go out of pocket. And I've had many, many employers be shocked by that because you come in and meet with them and you say, why are you telling me about the National Labor Relations Board? I don't have a union. And that's not the way the law is structured or works. Similarly, with regard to other types of laws, whistleblowers and laws regarding anti-retaliation, if the conduct is protected, if it's protected if I say it within the context of the workplace, it's similarly protected if I'm saying it on Facebook. So has to be done on a case-by-case basis to really look at the conduct and say, is this disparagement? Is this defamatory? Is it actionable? Or is this really trending towards protected concerted activity, and I'm just going to have to, as an employer, hold my tongue and live with this? It's a very difficult analysis to make. In addition, there are state laws that come into play when you start talking about off-duty conduct. The 4 in particular are California, Colorado, New York, and North Dakota all have statutory provisions that, at least on their face, say that you can't terminate someone for off-duty conduct that is lawful. Now, the good news is they really aren't that broad. Even in California, there's been litigation back in the mid-2000s that showed no, actually the General Assembly didn't quite mean what it said in the statute, and it's much more narrow than that. But the short version is there are state law implications, and if you're in any of these jurisdictions that have provisions about protecting off-duty conduct, you need to be cognizant of those before you take any type of action.
And of course, even if your nonprofit is based here, but you have employees, even a single employee works from home in any of those jurisdictions, those laws are likely going to apply.
Yeah, excellent. Thank you, Jeff. A few words about social media and social media policies. Again, the key here is to always focus on the expectation of privacy because that's going to be the driver of permissible versus illicit conduct. So we recommend that you have specific disclaimers waiving any right to privacy, inform your employees similarly with regard to email. It's not considered private. Even if you have personalized passwords on your computer, those belong to the company. They're simply on loan. This is an area where handbooks and strong policies and handbooks are very important. You want to have good, strong language there about the limited expectation of privacy. Equally important to have something as simple as an acknowledgement from the employee signing that, yes, I did receive the handbook and I reviewed it when I came on board. It's going to take you about 95% of the way there when push comes to shove 3 years down the road, and they're saying, well, wait, what do you mean you're looking at my email and I'm being terminated for this? So this is an area where, again, the proactive policies are essential. as Grace talked about before, notifying employees about what we are going to do. With my advocate's hat on, I'd say, yeah, just a policy that says we own it and we can do whatever we want is going to be good enough. With my counselor's hat on, I'd say, no, let's really be very clear about the type of monitoring that we can do, we may do, and again, because all of that goes to buttressing the argument that no reasonable person could be sitting in their office thinking that they have any expectation that what they're typing on the machine is not being read or capable of being read by the employer. With all of that, though, and given the overlay of federal law and state law, when you're dealing with out-of-work conduct or conduct that's either off-duty or occurring outside of the workplace, you really do have to proceed with caution, if only because of the squirrely type things that we sometimes see coming out of the National Labor Relations Board, and also at the state law level, and just from a gut check level, that employees will have an expectation that if they're off duty, what they're doing is their own personal time. The fact of the matter is that's not always the case, and certainly not always the case from management's perspective. And the more that we can do from a policy and practice to educate them of that fact, the much less likely that you'd have to deal with issues in litigation down the road. And with that, I'm going to turn it back to Grace.
Thanks, David. Just before I talk about sort of the nitty-gritty of what you want to have in your policies, I want to piggyback off what David just said. In terms of social media, it's not only important to have a policy, it's one of those areas that we're really doing a lot of training on. If you already do sort of sexual harassment prevention and discrimination harassment training, we've been adding a sort of a social media component to that training, because a lot of times what's in your policy is just a bunch of words and people don't really get what that means. Some people aren't on Facebook. Some people are, and they know every in and out of every single privacy setting there is. But in today's sort of generation of, what do you mean I can't put everything about my life on Facebook and Twitter? I don't understand. Why is there a boundary? It is important to sort of train employees, especially those who've grown up with this technology and it's just second nature to them to communicate this way and communicate everything to everyone. To really establish those boundaries. It's mostly important because you'd be surprised how much confidential information gets leaked out over these blogs and Facebook and things like that. So you really want to be careful to do that. So with that in mind, I'm going to talk about, sort of in addition to training, what can you write in your policies? First of all, if you don't have a policy, you got to have a policy. So go back to your organization and tell them that the lawyer said you have to have a policy. And if you have a policy but it's a few years old or even more, update the policy, because the technology has changed drastically, and the law is changing, especially this Section 7 rights under the NLRB. You really want to be careful to include that and to consider that when you're drafting these policies, because there's a lot more enforcement in that area. So just a few sort of general takes for the policy. A zero tolerance policy is not recommended. No workplace today is realistically going to enforce a policy that says you can never use our computer for personal reasons, you can never use our computer, our work email for personal use. And in fact, a lot of people say it's encouraged and it's okay because it may increase your productivity at work. If you can do a little bit of online banking, it might save you a trip to get in your car and go to the bank and wait in line and do all that. And with this sort of we're working all the time from anywhere and everywhere, it can increase productivity, but you also want to be careful not to be overly broad and say, yeah, go ahead and use our stuff for anything you want. A good middle ground is to say a reasonable personal use is okay as long as it's not harming our business interest or offensive to others in the workplace or our member associations or our reputation. So that's sort of a middle ground that we often see. An electronic communication policy must include things, to protect your organization's assets, your member list, your trademarks, your copyright information, protect your reputation. What can you and can you not say on Facebook or on Twitter. Don't talk about the hot dogs from the party. Talk about it to me. Come to me face to face and talk about it. What a concept. It can increase productivity, so do take that into consideration and ensure that it's complying with the law. And again, we've talked about a number of different areas that you should look at, and the biggest piece of that is obviously this expectation of privacy and making sure that you set that clearly.
And a quick comment on the policy piece, because one thing, I had a client that actually did get an NLRA complaint, was a policy that said, in essence, everything that happens inside of Acme Corp is considered confidential and shouldn't be shared with third parties. And the NLRB came in and said, you can't say that, because the employees have the right to talk to, one, amongst themselves when they're not on duty about wages and things like that, and they certainly have the right to talk to us or a union organizer. So it really is a balance, and I mean the hot dog comment is an interesting one, because if you had a policy that said, in essence, don't complain outside of work, the NLRB would look at that and say that has a chilling effect. So they do have to be drafted with care, and with oftentimes we have a line or an acknowledgement in there that says that acknowledges Section 7 rights, and say this policy does not infringe upon Section 7 rights. Now, do the employees understand what Section 7 rights are? Probably not. But it's something that's in there as sort of a safe harbor within the policy. So again, just that blanket ban that all of us would feel very comfortable with and say, don't talk about it outside of work, come talk to us, government would look at that and frown.
So going back to sort of what you want to have in your policies, be specific. What type of monitoring are we talking about? Are we, what's the frequency of monitoring? Again, if you don't have the resources or the desire to watch everyone's computer every minute of every day, don't say that you're going to do that. And if you say that you're going to do it, then you actually have to do it. Otherwise, you really are sort of not enforcing your own policy. What is the purpose of the monitoring? What's that legitimate business reason? Make sure it's consistent with your other policies, with your sexual harassment policy, with your codes of conduct policy. What is the scope of monitoring in terms of personal email, voicemails, your personal iPhone, that's synced up with your work email, video monitoring? Really, don't be too specific, because you don't want to paint yourself into a corner. But if you know you're going to do certain things, there's no harm in sort of putting people on notice and decreasing the expectation of privacy. Yep.
On that point, if you put in writing that you have the right to monitor, let's say you have 300 employees, and you get word of some maybe inappropriate activity for one, and is there a defense, I'm the only one in 300 that you ever monitored? In other words, you said that you have to do monitoring if you say you're going to do it, but what if you don't have the resources, but you will use it, let's say, with a special consultant or something?
Right.
Like that?
That's fine. Absolutely. The question is, what if you don't monitor and you say that you reserve the right to monitor, and you have 300 employees, and one situation comes up and you have to do basically an investigation, and that employee says, what, I'm the only employee out of 300 that you're going to monitor suddenly? Again, there's a legitimate business interest there. You're doing an investigation. You may suspect misconduct, something like that, and therefore you are exercising that right that you reserved in your policy, and that's okay. Again, in your policy, if you have filtering systems, some people have websites that people can't access on there. You might want to put that in there. Establish clear security provisions, passwords, especially with these mobile devices. Tell people they have to have a password on their BlackBerry. That information is just walking around with people. If you have external hard drives that people can take to and from work, what are you doing to secure those? What are keeping your laptop in a secure place so that if you are a subject of car theft, suddenly all of our intellectual property doesn't go out the door with you. Establish your guidelines regarding the use of portable devices such as laptops and BlackBerries, especially about what happens when you leave and whether or not we're going to say, you know what, we've got to wipe that thing before you walk out the door.
Grace, I have a question from the webinar, and it's I think kind of a theme that's been asked about here today. The question really is, Certainly what you've made clear is that just because you have a policy that says it reserves the right to monitor doesn't mean you actually have to monitor. And certainly when you do decide to monitor someone, if it's prompted by some suspicion of wrongdoing or inappropriate conduct, that certainly would seem to help in laying the groundwork for that. But the question really gets to, what if you're being sporadic in your monitoring, and what if you're only monitoring, occasional lower-level employees who maybe the supervisors don't really like as much and are trying to find some dirt on to get rid of, and no one's monitoring the management, which a lot of the lower-level employees suspect are really abusing their, Facebook to do and say things that are inappropriate. When can you get into trouble for doing kind of subjective or complaint-based, or if you're doing kind of selective subjective monitoring, can that in and of itself create problems for the employer?
I think it's one of those situations where with any policy, you don't want to do it in a discriminatory manner. So you don't want to only monitor the emails of a certain race. You don't want to only monitor personal use of, the laptop for women or just the men. I mean, to monitor lower level versus management is not going to get you in as much trouble, because there is an argument to be made that a legitimate business reason, we see statistically that, lower level employees are not as productive, and they, we're worried about their productivity, and therefore, or maybe they're non-exempt. So we have to make sure that they're really working when they're working and they're not working when they're not, so that we're not, facing wage and hour issues there. So that is, generally speaking, that's okay, although there's a couple of pitfalls in terms of discrimination and things like that.
Yeah, and let me just wanted to talk to one of them, because this is relevant to the background check portion of the slide deck, which we are undoubtedly not going to be able to get to today. So certainly if you see those slides, have any questions, feel free to give a call or drop an email, both anyone in the room or online. And that's the issue of disparate impact. Real world example, had a hospitality company that was going to institute background checks on new hires, and they were going to start with the groundskeepers. And looking at their workforce, the groundskeepers were overwhelmingly Hispanic. And I said, here they were going to be doing a rolling rollout. So they were starting there, and then they were going to start doing other areas of the company. And I said, what's the business justification for starting there? And they said, well, that's just what we decided to start. I said, that's fine, but you have to see the optics of this are horrendous. So they ultimately did something which was different and sort of did randoms throughout their organization. And again, no discriminatory intent, but there it was just the optics were bad. But that's type of issue often you see at any workforce in terms of the younger, more junior employees tend to have a more diverse profile than older, more senior executives. So you could have a facially neutral policy that tends to screen out, i.e. more people are found abusing the internet at lower levels, and those people tend to be minorities, depending on how you're implementing your monitoring plan. And it's the classic, who's watching the watchman problem. And generally speaking, for smaller organizations, what we say is have the policy that's in place and say, yes, we can monitor when we choose to. We don't have to tell you. We can do all the things that Grace was talking about, providing us or giving us the ability to do, because we don't want them to have any expectation of privacy. But then you have the internal policy that says it has to be the most senior executive that pulls the trigger on that. So it has to be the executive director, or a manager themselves doesn't have the right to go to your IT vendor and say, hey, I'd like to see all the emails for Grace Lee. That there needs to be a process built in just so you don't stumble into this issue of management abuse, because it can be abusive, and we have seen it be abused. So it is something that needs to be concerned with, and need to have some internal controls to make certain that it does not get misused and you don't stumble into, be it a disparate impact or a disparate treatment type claim.
Okay, I have one final question from the webinar, and I'm going to ask both of you to spend a minute or two summarizing any final thoughts, because we're unfortunately not going to have time to get through the rest of the slide deck. The question essentially is, how do these rules, these recommendations, these policies, particularly regarding the right to monitor, the right to inspect electronic devices and other electronic communications, how do they apply, or do you recommend that they apply or not to independent contractors? Certainly, you don't have the same employment law protections for independent contractors that you have for employees. So taking those issues aside, you still have some of the same very important interests in terms of protecting the company's confidential information and trade secrets, and whatever rights that you negotiate are going to have to be contractual rights that are negotiated in hopefully a written agreement that you have with that independent contractor. But what's your general kind of advice or guidance in this area?
Yeah, my general advice is exactly consistent with your last clause, is that in the independent contractor relationship, you're not going to have the overlay of common law agency that I, as the employer, are going to be on the hook for this individual, so I have the right to be sort of kicking over their sock drawers while they're at work here, because if they're engaging in discriminatory conduct or any other misconduct, I'm going to be on the hook for that. That's not the case with an independent contractor relationship. So your interests as an employer, though, are the same. If you've got an independent contractor who's harassing your staff, harassing members, you're going to be implicated in that claim and in that lawsuit. But so what you need to do is within that, within the contractual arrangement, build in all of the things that we've been talking about in terms of if they are using, if they have access to your network, which is very common for independent contractors, that you do have the right to monitor, that, the tools that you're providing to them are, the same as if, or rather we have the same rights to access them as we do other employees who are direct W-2s. But if you don't do that, Jeff's absolutely correct that it's a very different legal framework. So I think it's important to be proactive, look at your independent contractor agreements and make certain that they understand that they don't have any expectation of privacy when they're using your network or whenever they're conducting business or acting on your behalf.
Okay, that was great. Can both of you just take maybe 1 minute or so to each kind of summarize any final thoughts, anything that we didn't cover that you think it's important to pass on, highlight anything in the slide deck that we didn't get to, and then get a wrap up?
Go ahead.
Sure. I just want to say for this mixed-use device, we talk about in the slides sort of some things that you want to include in there, but I really want to emphasize the use of an agreement. So if you have an employee who comes to you with their personal iPhone and says, I really want to use this, I don't want to carry two things, have an agreement that they sign, they acknowledge, and that sort of it's a contract, and that's going to go a long way. The final tip that I have for you is any kind of software that you can use, that good software to wall off from an intellectual, an IT perspective. Some of this company information is going to really go a long way to protect you and to give you more control over the information that's walking around out there. And finally, don't ignore the exit interview when it comes to privacy and the return of company property and the return of company information and data. A lot of people work from home. They work from their home computer. They may not be saving everything back to the server. And so when they leave, you may have just lost a huge amount of information that can only be retrieved if you go back to that person's home computer. What kind of rights do you have in that information, and how are you going to enforce that? So really take advantage of that exit interview. Make sure that you get the information that you need back from people and the equipment that you need back from people before they walk out the door. And then for everything else, I'm gonna leave it to David to summarize.
Yes. 15 seconds on background checks. The only thing I wanted to emphasize on the background checks is that this is a developing area and one that is getting increasing scrutiny from the EEOC. There's a couple of slides about the settlement that was recently reached between PepsiCo and the EEOC. It was a $3.13 million settlement, and the principal allegation was that their background check policy was having a disparate impact on minority candidates. And the EEOC has had public statements in various settings that they are increasingly taking a dim view of employers that simply have a blanket ban on criminal history. New York State has gotten in on the act and actually has a statute that makes it unlawful, presumptively unlawful, for an employer to say we don't employ convicts. It's acknowledged that the statistics are what they are, and that when you look at conviction statistics, you tend to have a greater proportion of minorities than their participation in the labor force. And the EEOC is taking the position that unless you can show that it is somehow job-related, that it's not equitable and it's having a disparate impact on minorities, to use that as a bar. So if you're using background checks, and credit history checks as well, and there are many, many legitimate reasons to use those for certain positions, you do need to be cognizant of the fact that it does have to be tailored to a specific position. The law hasn't gotten there all the way yet, but that seems to be the direction that it's moving. So if you're using, again, background check type information during the hiring process, you need to be able to articulate that business reason reason as to why this flag or why this conviction makes this person ineligible for this particular position. With that, I think we're done. We'll certainly be around for a few more minutes for anyone in the room that has questions. Feel free to pull any of us aside.
Yeah, I want to thank our speakers for a terrific program today. Thank you all for attending here in person and on the webinar, and hope to see you at our next program next month. Thank you very much.
Thank you. Please stand by.